This is the Thursday, January 10th, 2013 meeting of the Zoning Board of Examiners and Appeals. Would you call the roll, please?
Timothy Vig.
Here.
Dean Cars.
Here.
Jeff Ron.
Here.
Ann Denny.
Here.
Dale Patrick.
Here.
John Dunham. Deanna Willard.
Here.
Thank you. Next on our agenda are minutes for approval. We have no minutes for approval. Special order of business executive sessions. Are there any disclosures any of the board members would like to announce this evening? What just happened? I had them and I lost them.
Is it back now?
Nope. I think there were three. Mr. Patrick.
Yeah, I would like to disclose that I was not present at the September 13th, 2012 meeting, and will be abstaining from voting on Resolution 2012-027.
Thank you, Mr. Patrick. Mr. Vig.
I was not present at the October 11th, 2012 meeting, and I will be abstaining from voting on Resolution 2012-029.
Thank you, Mr. Vig. Ms. Willard, had I seen you in the queue early?
Yes. I'd like to disclose I was not present at the July 12th meeting and will be abstaining from voting on Resolution 2012-018.
Thank you, Ms. Willard. You got to give me a sec, Joe. Are there any other disclosures? Just 1 minute. Okay. Just for the record, Ms. Willard, just for clarification, you were in attendance at the meeting. You just recused yourself from that case. Is that correct?
That's correct.
Okay, thank you. So you'll be recusing yourself from voting on that resolution.
Correct.
Thank you. Are there any other disclosures? Seeing none, that moves us on. I guess prior to moving on our consent agenda, it appears based on the disclosures we have on Resolution 2012-029, on 2012-018, and 2012-027, we will have 5 board members that will be voting on those cases, or on those resolutions. For those in attendance this evening, when we hear variance requests or pass motions with respect to variances or resolutions, it requires a vote of a majority of the fully constituted board. There are 9 members on the fully constituted board, so any resolution or variance that is voted on requires a vote of 5 votes in favor. All those resolutions, either on the consent agenda and or the regular agenda, do have 5 members that can vote for those, so we can hear all those resolutions. That being said, we are just on the consent agenda, and we have 1 resolution for approval. Has everyone had a chance to review the consent agenda? Is there any opposition, or is there anyone that would want to pull the case from the consent agenda? Seeing none, do you want us to vote on it? Or? Okay. Could I have a motion for approval of Mr. McLaughlin?
You can take my question maybe after the vote. I apologize. I didn't mean to interrupt that.
Okay. All right. Could I have a motion for approval of the consent agenda, please? Mr. Ron, you've indicated you would moved to approve,
That's correct.
and Ms. Denny, you've seconded that.
Yes, I have.
Thank you. Is there any opposition to approval? Seeing none, the consent agenda is approved. Mr. McLaughlin.
Thank you, Mr. Chair. I lost track of which resolutions would be approved, and which ones would not.
They will all be approved. We have
great. Okay.
sufficient votes to approve.
I just know that the owners were really waiting on it, so I thank you.
You bet. We have no appearance requests or unfinished business and actions of public hearings. We do have 3 resolutions for approval on our regular agenda, which is not typical. Is that something you wanted to speak to? Ms. Graves, would you care to speak to those resolutions?
Yes, these 3 resolutions were previously approved by the board, and the conditions of approval were approved by the board at that time, but when the resolutions were approved, the conditions were inadvertently left out. And so what we need to do is vote on a revised resolutions to include the conditions. So there are 3 resolutions in that manner. They each have different conditions that are being, a different number of conditions, though, that are being added.
Thank you. Are there, so we have, I'm assuming we can treat those the same way as, can we approve them all at one time?
I had thought that it might be okay to do a motion to approve all of them, but each one has a different, like, the first one has paragraph B, conditions 1, 2, and 3. The second one is adding paragraph B, 1 and 2. So I think maybe we ought to do a motion on each resolution because they are different. So I would appreciate that. Thank you.
Thank you. So with that in mind, Mr. Vig, I would entertain, would you care to make a motion, Mr. Vig?
Mr. Chairman, with regard to Resolution 2012-018, I move that we revise the resolution that was previously adopted on August 9th, 2012 to include paragraph B and conditions of approval 1, 2, and 3.
Thank you, Mr. Vig. Could I have a second, please? Mr. Patrick, you indicated you've seconded?
Yes.
Thank you. Is there any further discussion on that resolution? If not, please vote. Oh, is there any objection to approval of that resolution as moved and seconded by Mr. Vig and Mr. Patrick? Seeing none, that resolution passes. Mr. Vig.
Thank you. With regard to Resolution 2012-021, I move that we revise the resolution previously adopted on September 13th, 2012 to include conditions of approval B, parent 1 and 2.
Thank you, Mr. Vig. Mr. Patrick, you did such a good job on that first one. Would you care to second that motion?
I will second that.
Thank you, Mr. Patrick. Is there any discussion? Seeing none, is there any opposition to passage of that resolution for approval? Seeing no opposition, that resolution passes. Mr. Vig.
And with regard to Resolution 2012-027, I move that we revise the resolution previously adopted on October 11th, 2012 to include paragraph B and conditions of approval 1, 2, and 3.
Thank you, Mr. Vig. Mr. Patrick, you will be abstaining from that one. Thank you, Mr. Patrick. Ms. Denny, you'll second that?
I second that.
Thank you, Ms. Denny and Mr. Patrick. Thank you for being attentive.
That's right. That was one thing.
Okay.
I'm sorry, I have down that you can vote on this resolution, but Mr. Patrick can't. Am I?
Correct. Yes, that's correct. Mr. Vig was the main motion,
Oh.
and Ms. Denny seconded this one.
Okay, things weren't, my bad.
Is there any discussion on this motion? Is there any opposition to passage of this resolution? Seeing none, that resolution passes. Thank you all. That brings us to our first case this evening, and before we hear this case, I would like to read the order of business on variance hearings. The chair shall introduce the variance and explain the procedure to be followed. The variance case number and the name of the applicant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The board shall hear a brief staff presentation outlining the variance, not to exceed 10 minutes. On conclusion of the staff presentation, the board members and the applicant may then direct questions to the staff through the chair. The applicant shall give his or her presentation, not to exceed 10 minutes. Throughout the proceedings, the burden of proof rests upon the applicant, who must convince the board by a preponderance of the evidence that the variance should be granted. On conclusion of the applicant's presentation, the board members and the staff may then direct questions to the applicant through the chair. The hearing shall then be open for public testimony. Each person has 3 minutes. All persons who testify may be questioned by the board, staff, or the applicant. On conclusion of the public testimony, the staff, followed by the applicant, shall have the right of rebuttal, 3 minutes each. The board shall proceed to develop oral findings and conclusions with regard to the variance and disposition of the variance. The staff shall reduce the oral findings and conclusions to writing for subsequent adoption by the board at a later meeting. The matter then rests with the board, and the chair asks for a positive motion from the board. As I mentioned before, in order to grant a variance, it will require 5 votes in favor, which is a majority of the fully constituted board. That brings us to our first case this evening. The petitioner is Josephine Dagon. She's indicated she is here. Thank you. Could the staff provide us with the sufficiency of notice, please?
Yes, Mr. Chair. On December 19th of last year, there were 48 public hearing notices mailed. At the time this report was written, 1 response was received from the public. This public comment supports the variance. Also, the petitioners provided 6 letters of support from all the surrounding neighbors to the petition site. No response was received from the Rabbit Creek Community Council.
Thank you, Mr. McLaughlin. Would you proceed with the staff presentation, please?
Thank you. The petitioner is seeking a variance from municipal code to allow an existing accessory structure to encroach 11 feet into the 50-foot rear yard setback in the R6 district. This is on the hillside. Standard number 1 appears not to be met. The petition site is affected by steep topography that slopes downhill to the south. There is a 25-foot stream protection setback that runs along the south lot boundary. The rear lot boundary is irregular as opposed to straight because it follows the stream. On-site septic systems and a private well further constrain the buildable area on the lot. There are several physical constraints that affect the petition site, but these are not unique to the property. All the lots along this section of Rabbit Creek are affected by steep topography. and irregular rear lot boundaries. Standard number 2 also appears to not be met. The physical circumstances of the property do not create an exceptional hardship on the property owner or deprive the applicant of rights commonly enjoyed by other properties in this district. Accessory buildings are common in this neighborhood. However, the petition site has ample space to place an accessory structure in a conforming location that does not encroach into this 50-foot rear yard setback. The physical constraints on the property do not create the need for the variance. The petitioner built a 220-foot accessory structure, square foot accessory structure on foundation without a building permit. Standard number 3 also appears not to be met. The need for the variance is self-imposed. If the owner had obtained a building permit, then she would have built the sauna in a conforming location. Standard number 4 is met. The neighboring properties, the south, west, and east, will be unaffected by the granting of the variance. Standard number 5 is met. It's a dimensional variance, not a use variance. Standard number 6 is also met. There are no health or safety issues identified. Standard number 7 appears not to be met. There are other conforming locations to locate a sauna. This is a 22% encroachment into the rear yard setback. The department finds that standards 1, 2, 3, and 7 do not appear to be substantially met and therefore must recommend denial of the variance. If the board finds that all 7 standards have substantially been met, the department recommends approval subject to conditions 1 through 5 on pages 4 and 5. The conditions 1 and 2 are standard. 3, 4, and 5, I'll just mention an explanation. Number 3 is to obtain an after-the-fact building permit. Number 4 is to resolve with on-site water and wastewater services division the undocumented private well and septic system. And condition number 5, the petitioner would confirm with Watershed Management Services that the structure is located outside of the stream setback. This is really more of a formality, this last condition of approval, because it appears that the structure is well outside of the 25-foot stream protection setback. But Watershed Management Services commented that they wanted to wait till the spring to double-check this distance. That's all I have. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of staff by the board? Any questions at all? Mr. Vig.
Thank you. Mr. McLaughlin, if we were to approve this variance with these conditions that you just outlined, and for some unforeseen reason it turned out that condition number 5, that there was an encroachment into the stream setback, what would be the standing of this case at that time?
They would have to apply for a variance and come back before the board for that. Before they submitted this application, the owner's representative worked with a surveyor to determine that the structure was outside of the stream protection setback, because they pay 1 fee and they can get up to 3 variance requests with it. So I wanted them to make sure that it was outside of the stream protection setback so that they could apply for 2 variances at one time if they needed to, and they didn't need to do that. But the one thing that was missing is they didn't loop Watershed Management Services in on the mapping that they did, and so Steve Ellis, who represents that agency, asked for this sort of formality. He said to me that he thinks it's outside of the stream setback, but he still asked that the condition be there. So you would get another look at the variance. They would have to come back before you again.
Okay, thank you.
Are there any other questions of staff? I do have one question. I believe in the write-up, the petitioner, maybe I misinterpreted, but sounds like they might be looking to expand or add on, put a studio in. Do you know, are they looking to revise this shed at all, the configuration of the shed?
Mr. Chair, I did not ask, you're correct that that's how this was discovered. They were submitting for a building permit, but I guess I just assumed that the building permit for an addition was to the house. But if I was wrong in assuming that and it was for the sauna, as long as that it was on the side, it didn't increase the encroachment, that would be allowed.
Thank you. Thank you. Are there any other questions? If not, could the petitioner come forward, please? Could you state and spell your name for the record?
Yes, my name is Elizabeth Holmgren. It's Elisabeth, and the last name is Holmgren, Holmgren.
Thank you, Ms. Holmgren. You have 10 minutes for your presentation, and again, we must find that all standards are met in order to grant a variance. So if within that 10-minute time, you can make sure you address the 7 standards as part of your presentation.
Okay, thank you. My name is Elizabeth Holmgren. I'm here, I'm an architect. I'm here with the owner, Josephine Dagan. And I'm here because, as Francis said, when we were considering an addition to the house, we discovered that the sauna was within the rear yard setback. I'd like to thank Francis's office for all their help and for their time in this matter, and I'd like to thank the board for your time and your review. Thank you. We agree with the staff review that standards 4, 5, and 6 are substantially met. We also believe that standards 1, 2, 3, and 7 are substantially met. We believe that standard 1 is substantially met. If you look in your report, your staff report, you'll see on pages 18 and 19 the contours for this area and this lot in particular. And you'll see that this lot has much more slope and much less flat area than any of the other lots in the area. It is very steep topography here. The lot, as Francis says, is very irregular in shape. If you drive by the top on Rabbit Creek Road and you look down there, it's hard to even imagine that there's a house built there. It is so steep. The pictures don't do it justice. And the driveway traverses across the lot and is still extremely steep. You definitely need a 4-wheel drive to get in and out of there. And when they built the existing house, which was built by Josephine's dad, they brought in considerable fill. To go anywhere else on the site, you actually go down sets of stairs, which are as steep as a house stairs, traditionally in a regular 7 by 11-inch steps, risers and runs. This is an alpine slope development, and it is some of the most challenging topography in the Anchorage Bowl and the Eagle River area. Standard 2, we believe that this is substantially met. As I said before, this is very steep topography, and there are large setbacks. There are only 3 building locations. One is where the existing house is, another is the septic field, and the third is where the sauna is. That is the only place to build the sauna without being in another setback somewhere. We also believe that standard 3 is substantially met. The owner has no control over this very irregular shaped lot or the topography. This is an alpine lot with a mountain stream, and it's in a very deep ravine, and it is an environmentally sensitive area. When the subdivision was created, they made very irregular, difficult lots with limited buildable area, and there's no access to public water or sewer. when the owner did go to build this sauna, she did seek compliance. She went to the planning department and she gave her address and asked what the rear setback was. She was told 25 feet, so there was apparently some misunderstanding or miscommunication because that is the stream setback and not the rear yard setback. So she built accordingly, and she also inquired about needing a building permit, and she was told that if it was under 200 square feet, she would not be required to have a building permit. They built it, and it is 10.8 by 20.4 feet, which adds up to 220 square feet. That was inadvertent. That was not intended. This is her family home, and I'd like to just read a quote that she wrote about the property and the building of the sauna. She said, "I love the home here and the surrounding flora and fauna and keep it as preserved and wild as possible. In the building process, I was very concerned and careful to protect it. We hand dug all the post holes and carried the dirt out in buckets up the steep hill on a narrow walkway to the driveway. We hand carried all the materials in as well. Very little shrub vegetation and no trees were disturbed. It was my intention to protect and to add only beauty to this natural setting." If you walk in here, even though this area is used, you see that it's completely virgin and protected, as she said. We also believe that Standard 7 is substantially met. There's no other location available for the sauna. The encroachment is not visible to neighbors. This is a very wooded lot and a deep ravine. The encroachment is very small. It is only 11 feet into a 50-foot setback. This building is an asset to this area. It's a beautiful building. The character of the building has beautiful trusses. The character is perfect for a wooded setting. It's really a gem, and it was built to enhance the beauty of the natural setting. As Frances said, Joe's went around and visited all the neighbors, and you can see on page 20 she even visited some neighbors that are beyond her site that do not border the site, and she explained the situation. There were no objections. As a matter of fact, everybody was very much had enthusiastic support for the sauna and for the variance, and the letters are in your packet. And I noticed that the letters were not as clearly stated as they might have been, but she explained the situation to everyone. And then when we got the survey back and we confirmed that it was 11 feet into that setback, I telephoned each one of these people again, made sure they understood it was 11 feet, and once again, they all supported it. I'd like to reserve my remaining time for rebuttal.
Thank you, Ms. Holmgren. Are there any questions of the petitioner by the board? Mr. Vig.
Thank you, Ms. Holmgren, for your explanation of the standards. And you, in your presentation, mentioned that there were basically 3 feasible building areas on the property, one where the house is and another being where the septic is. And I'm looking at the survey that's in the packet, and at least I didn't notice whether this septic was located on that map or not, or can you
It's not on that map because the septic is, as you're looking at the site, the septic is a little bit to the west. It's at the same level as the house, but it's on the western end. And I'm not sure, but it looks like they brought in fill to do that too, did they? Yeah, they did bring some fill in there because that area is flat, but it is the septic field.
Okay, thank you.
Mm-hmm.
Mr. Ron.
Thank you, Mr. Chair. Ms. Holmgren, could you describe for us the foundational structure of the sauna? Is it a cast-in-place foundation? Is it on piers?
It is on piers. It's very stoutly built, very well built.
Are there any other questions? I'd just like to follow up to Mr. Vig's question and your response. It appears on the record drawing there are a couple small circles drawn on the as-built on either side of what's identified the firewood crib. I believe it's on page 6 of the packet. Are those the location of the septic, or the approximate location of the septic standpipes?
Yeah, it's hard to tell how the slope is here, but yes, the septic is beyond that firewood crib, which really starts to get into the 25-foot setback on that side of the lot.
Okay.
I think all this, I guess you don't have, there's another drawing, the survey showed all the setbacks too, but I don't see that. Is that in here, Francis? I had a survey drawing. That's just that one doesn't appear to show the setbacks. Not the side yard or the backyard or the front yard setbacks. But yes, you're correct. That beyond the firewood crib is the septic.
Okay. Thank you. Are there any other questions of the petitioner by the board? Does staff have any questions?
No, Mr. Chair.
Thank you. Well, if not, we will open the hearing up for public testimony and
Okay, thank you very
allow
much.
you for rebuttal. Thank you. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any? Oh, yes, Ms. Holmgren.
I want to say thank you again for your time and your review of the variance and ask for approval of the variance.
Thank you.
Thank you very much.
So since you did have time for, was that your rebuttal time? Was that part of your rebuttal time? Thank you. Thank you, Ms. Holmgren.
I have no comments. Thank you.
Thank you. With that, the matter rests with the board. Could I have a positive motion from a board member, please? Mr. Vig.
Thank you, Mr. Chairman. In case number 2013-006, I move that we grant a variance from AMC 21.40.080G.3 for an existing accessory structure to encroach 11 feet into the 50-foot rear yard setback, subject to conditions 1 through 5 contained in the staff packet. Thank you.
Thank you, Mr. Vig. Ms. Denny, you've indicated you would second that motion?
Yes, I have.
Thank you, Ms. Denny. Mr. Vig,
Thank you.
speak your motion, please.
Yes, thank you. I have to admit I kind of struggled with this one a little bit as I was reviewing the case before the meeting today, and I think the applicant did a good job, at least in to remind me of the topography on this particular lot. And I was attempting to find the topographic map that was in the packet, but it did show I guess it's on page 18, and the density of the contours on that particular lot are much greater than what appears to be the lots up and down Rabbit Creek Road on either side of the street. And so, with regard to standard number 1, I do think that there is a case to be made for that standard being met with these unique physical circumstances of the property that are not present on other properties in the district. So I believe that standard is met. Standard number 2, because of those physical circumstances, strict application of the code would deprive the applicant of rights commonly enjoyed. And I think she also did a good job of explaining the limited availability of somewhat level terrain on the lot that could be used for an accessory structure, and if the house occupies one of them and the septic field occupies the other, it severely limits the ability to construct an accessory structure that is commonly enjoyed in this district. Standard number 3, I'm still a little bit on the fence on that one as far as whether the hardship is self-imposed. I'd like to hear some discussion by the other board members on standard number 3. But I do concur with staff in their findings of that standards 4, 5, and 6 are substantially met, that the variance if granted would not adversely affect the use of adjacent property, and it will not change the characteristic of the zoning district or adversely affect the health, safety, and welfare of the people of the municipality. So I do believe those standards are met as staff indicated. And with regard to standard number 7, again, going back to the limited buildable area in the lot, if there are no other alternatives, then I think there is a case to be made that this is the minimum variance that would make possible a reasonable use of the land. So I believe that standard is substantially met. And depending on the dialogue I hear on standard number 3 from some of the other board members, I could be inclined to support the motion. Thank you.
Thank you, Mr. Vig. Ms. Denny.
Yes, I agree with Mr. Vig, and I do intend to support the motion. Looking at the contour map on page 18, it does show a very harsh environment for building any kind of a structure, and that including the 50-foot yard setback, I would say that would severely limit the areas that you are able to build any kind of structure at all. As to standard number 3, I do believe the owner made a good faith effort, even though she may have been misinformed when she originally applied for a permit or sought to find out if she needed a permit, when she was told that she was only had a 25-foot setback instead of a 50-foot, which she found out later, and that the original size of the structure was intended to be included in a 200-square-foot area. And as far as standard number 7, that I do believe that is the minimum use for this variance. And like I said, I do intend to support the passage of this motion.
Thank you, Ms. Denny. Are there other comments by any comments by other board members? Mr. Ron.
Thank you, Mr. Chair. I'll speak briefly to Mr. Vig's request for comments for standard number 3. I as well initially had difficulty in reviewing this case, but appreciate the petitioner representative's testimony and feel that they stood up to their burden of proof and provided evidence that made my vote a little easier. If I could step back to standard 2 regarding exceptional or undue hardship, I initially had difficulty with whether or not an accessory structure can be tied to this idea of exceptional or undue hardship. But looking more closely at the petitioner's initial construction of that accessory structure in their attempt to minimize harm to the property, I think that we'd be creating a hardship not only on the property owner but perhaps on the property itself, and would hope that we can maintain the petitioner's interest in minimizing harm to the property by requiring them to move or demolish that accessory structure. And in that sense, I find that the hardships of slope, topography, stream setback, and such are not self-imposed, and I do intend to support the motion. Thank you.
Thank you, Mr. Ron. Are there any other comments by any of the board members? I would just like to comment, I also intend to support the motion, agreeing with the the findings of Mr. Vig, Ms. Denny, and Mr. Ron. And with respect to Standard 3, the hardship being self-imposed, the staff had made the comment that if the owner had obtained a building permit, she would have built the sauna in a conforming location. This is one of those items we wrestle with quite often. Another way of looking at it is the petitioner would have identified at that time the need for a variance come before this board prior to construction, which again should have occurred. However, with that in mind, based on the information that's provided by the applicant to us in the discussion this evening, I feel comfortable that it probably would have, well, I'm sure it would have been approved at that time as well for the reasons that were discussed with respect to the topography, the shape of the lot, and that there's really the only people that are impacted by this are the property owners themselves. Most other residents aren't able to see this because this portion of the lot is so low. So I also intend to support the motion. If there are no other comments, please vote. That motion passes by a vote of 6-0. For the record, I must read, every final decision of the board shall clearly state on its face value it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That brings us to our next case this evening, which is case number 2013-005. The petitioner is Terry Berg. Is the petitioner here this evening? He's indicated he is. Could staff provide us with the sufficiency of notice, please?
Thank you, Mr. Chair. On December 19th of last year, there were 128 public hearing notices mailed to the neighborhood. A member of the Mountain View Community Council provided comments opposing the variance. Also, one public comment was received in opposition to the variance. The petitioner has provided 5 letters of support, and those have been laid on the table for you. There are 2 laid on the table items. One is the 5 letters of support from abutting neighbors provided by the petitioner, and then the other one is a letter from the same person from the Community Council who wrote the letter of opposition that's included in the packet. It's on, the letter in the packet is on the Community Council letterhead, but I think in the first sentence of the letter he states that that the Community Council has not met to discuss the variance request. So he's provided, my point is that one person wrote 2 letters of opposition. That's all I have.
Thank you, Mr. McLaughlin. It doesn't, I guess on that, if we're talking on page 42 of the packet, it doesn't say that that's not what I take out of this letter, that they didn't have a chance to act on it. It was just
the executive committee was the only group that was able to meet. Is that
okay?
Yeah. Let's just read it. As there's not another meeting of the Mountain View Community Council before the deadline of December 31st, the Mountain View Executive Committee would like to submit comments regarding zoning variance for this. There's no signatures from these folks on there. I don't know. I do know that Mr. Daniel George drafted this letter and the other one that I've laid on the table tonight.
Okay, thank you, Mr. McLaughlin. Would you continue with your presentation, please?
Thank you. The owner of this property would like to convert this single-family house into a triplex, which requires different yard setbacks. As a single-family and duplex, the side yard setbacks are 5 feet. As a triplex, they jump up to 10 feet. They double the yard setbacks. And this is on the north side and the east side. Therefore, the owner must obtain a 2.8-foot encroachment variance on the north side and a 10-foot encroachment variance on the east side abutting the alleyway. Standard number 1 appears not to be met. There are no exceptional physical circumstances of the land that warrant the granting of a variance. The lot is not affected by slopes, streams, or wetlands. It's served by public water and sewer and has the same rectangular shape as other lots in the same district. Also, the lot exceeds the minimum lot area in the R3 district by 250 square feet. However, this is a corner lot abutting the alley. An alley, so the primary and secondary front yards are abutting the streets, and the 2 side yards are along the north lot boundary, and the other side yard is along the west lot boundary, the alleyway. The house and attached garage were built under approved building permits issued between 1959 and 1979. The house was approved by the Board of Examiners and Appeals for variances in 1997. Standard number 2 is not met. Prior to 1965, the property was zoned R2. The R3 zoning came into effect for this property on September 13th, 1965. The house was approved for a building permit on September 27th, 1965. The owner at the time may not have planned for the possibility of converting the house into or building a triplex as it was not permitted in the R2 district, which was the zoning in effect until 14 days prior to the building permit being issued. The neighborhood has a mix of single-family, duplex, triplex, fourplex, and much greater multifamily housing. Multifamily housing is a common right of enjoyment and may be considered it may be considered a common right of enjoyment. Standard number 3, the standard appears not to be met. There is no peculiarity of the lot. The lot is essentially the same as others in the same zoning district. The need for the variance is a result of the petitioner's desire to convert the single-family house into a triplex. The house meets the required 5-foot side yard setback on the north as a single-family and as a duplex. Also, the board approved the 5-foot side yard variance on the east side, in part because the garage was built to the east lot line under an approved building permit in 1979. Technically, the petitioner has to reapply for this variance because the yard setback is increased when he tries to convert into a triplex. Standard number 4 appears to be partially met. There is a potential impact on the neighborhood, neighboring lots of an increased number of residents on this lot without meeting the required yard setbacks. However, this is an R3 multifamily district, and there are a number of apartment buildings within a 1-block radius. Also, the house has existed in its current location for many years, and no building additions are being proposed at this time or with this request. Standard number 5 is met. The requested variance is for side yard encroachments. It does not change the character of the zoning district. If the variances are granted, then they would not permit a prohibited use. Standard number 6 is met. The variances will not cause a fire separation distance concern. The variances do not appear to adversely affect health, safety, and public welfare. Standard number 7 is not met, appears not to be met. The variance requested on the north side is 2.8 feet, 28%. The variance requested on the east side is 10 feet, that's 100%. Note that the attached garage was built all the way to the east lot line under an approved building permit in 1979 that was issued in error. This 5-foot encroachment was approved for the 100% variance by the board in 1997. I suspect it's because that the building official made the error because this sort of tricky part in our code where a lot abutting an alleyway may build a garage all the way up to the lot line as they did here, but because this is technically considered a corner lot, that's a side yard and they can no longer do that. It's kind of complicated, but there are definitions of what is an alley and what is a street, and the definition of a street is that it does not include an alley. So the ability to build up to the alleyway is allowed for all the other lots, but not on a corner lot. No variance is necessary for the property to be used as a single-family house or a duplex. The variance is a result of the desire of the owner to convert the house into a triplex. A reasonable use of the land already exists on the property. The department finds that standards 1, 2, 3, 4, and 7 do not appear to be substantially met for either of the side yard variances, and therefore must recommend denial of both variances. If after the public hearing the board finds that all 7 standards are substantially met, the approval should be subject to conditions 1 and 2 on page 8. I'd be happy to answer any questions. Thank you.
Thank you, Mr. McLaughlin. Are there any questions of staff by the board? Ms. Denny.
Yes, Mr. McLaughlin, if the owner chose to develop the property as a duplex instead of a triplex, then he would not need to have a variance?
That's correct.
Thank you.
Thank you, Ms. Denny, Mr. McLaughlin. Are there any other questions? If not, could the petitioner come forward, please? Could you state and spell your name for the record?
Yes, Terry Burge, Terry Burge.
Thank you, Mr. Burge. You have 10 minutes for your presentation, and again, we must find that all 7 standards are met in order to grant a variance, so could you make sure that you address all 7 of those in your presentation, please? Thank you.
Thank you. Good evening, and again, my name is Terry Burge, and I'm the owner, along with my wife Ann, of the property on 4001 Thompson. And I apologize for reading. I generally don't like to do that. But first, let me thank you for allowing me the opportunity to present my thoughts to you this evening. And second, I'd like to thank the staff of the Planning and Zoning Division, specifically Francis. While I've been involved with building permits a few times in the past, this is the first time venturing into the variance process, and it has been a positive experience, and the staff has been extremely helpful. A little bit about me. I've lived in Alaska since 1975, moving here with my dad in the military and attending UAA, being one of the first to seek a telecommunication degree. I started working at Chemo TV in 1979, and after 12 years started my own video production business, Light Sounds LLC, producing videos for many clients and winning an Emmy Award for my documentary on the 2006 Iditarod Sled Dog Race. Being self-employed, though, I have a very limited retirement. Growing up, as we moved around, my folks would usually buy a house where we were stationed. We always left the house better than we found it by doing many improvements. I learned carpentry skills from that experience. I've also personally taken our small 750 square foot house we purchased in 1982, increasing it to over 2,000 square feet, where we still live to this day. The equity from that house has given us the ability to look for a few properties to fix up and use as our retirement. We purchased a foreclosed fourplex about 18 months ago, and as you can see in the pictures on page 21, I've replaced everything, making a nice clean building that is fully rented with happy tenants. My video productions can attest I try always to give my clients more quality than they ask for. Last July, we purchased the boarded-up house on Thompson. That was foreclosed, had been empty for a year, and had fallen into disrepair. We purchased the property with the intent of turning it into a nice triplex like the majority of the surrounding neighborhood. It is a large 13-bedroom house out of character with the community, not unlike those found on the hillside. We had found that the building had been used illegally for many years. We wanted to correct any violations and apply for whatever permits necessary to change the inside into a triplex. It has taken many months trying to ascertain what we could legally do. It appeared that we were a little too close to the property line to legally have a triplex, even though the outside of the building would not change. Hence, we are here seeking the variance. In addressing the 7 standards, let me say I agree with the standards that the department says that I have met, and I feel that I have substantially met all 7 standards. I will take a few minutes to address those that the department said are in question. Number 1, the property is a corner lot with 2 side yards, which with 2 side yards has limitations that others in the neighborhood don't have. Others can build garages up to the alley, but I cannot. The property has already been approved for a variance for 5 feet, so the need for a variance on the east side is now just a technicality. The house was also built in 1967, just prior to building codes that required 10-foot setback for multifamily properties. It could not have been foreseen what the future code would be, so if a triplex had been built then, it would have been grandfathered in. We're just talking a 2.8-foot encroachment in the positioning of the building. Number 2, there are 3 apartments with 6 or more units within a 1-block radius. If you look at pages 24, 25, and 26, you'll see some pictures. There's a 9-plex and a 4-plex right across the street, and more than 8 4-plexes to the north. Multifamily is a right of enjoyment in the neighborhood. The highest and best use allowed per the zoning regulations would be a 6-plex. We are being deprived of this because of the building being old. The property is zoned multifamily. I'm just seeking for a triplex. Number 3, since the building has been like this for over 45 years, I had no control as to its building. At the time, the area was predominantly single-family homes. The community has changed. The builder could not have planned for this. This is also out of my control, but I am not asking for more than what the zoning of the property already allows. Number 4, we agreed that the standard is met. The house has existed since 67, and I am not proposing any new additions. In the past, the building was used illegally. Number 5 and 6, the standard was met. Number 7, I am not proposing any new additions to the property, just internal modifications. The property footprint would remain the same as it has for over 40 years. In conclusion, I own a large 4,500 square foot distressed property that is out of character where it sits as a single-family home. The neighborhood is predominantly multifamily homes. The neighborhood is in need of additional multifamily units, and if I could cite the municipality's own Planning Division housing market analysis of March 2012, there will be a deficit of 3,594 multifamily units in the next 20 years. And that's found on page 31, table 7 of that study. Allow me also to quote from that study, quote, "The mismatch between demand and supply is serious and needs attention," close quote. And that's page 33, paragraph 2. The neighborhood needs more nice, affordable housing in the future, but it also needs it now. I am planning on keeping the building and not flipping it, so a nicer neighborhood is in my tenants' best interest and therefore in my best interest. I really do appreciate your time listening to my proposal, and I hope that you agree with my statements and grant me the variance. I would like to reserve the rest of my time for rebuttal, and I'd be happy to take any questions at this time.
Thank you, Mr. Burge. Are there any questions of the applicant by board members? Yes, Ms. Vlad.
Thank you. I appreciate your presentation. Wondering if you can walk us through the parking scenario on the site, just so I fully understand that.
Sure. Pardon me. Currently, and if you look on, let's see, I think it's page 22, the upper picture, you see the east side of the building. It's a single-story area. Currently, right in front of that is the existing parking, where there's about 5 or 6 spaces there. But the problem is that there's no turning around or anything like that. It would have to back across the sidewalk out into the street, which my understanding is that's a no-no. So my plan is to, and that end of the building has 3 bedrooms in it that are there illegally, especially the ones on the far right. They're right up to the alleyway, so they're not legal to be there. They make it look like a garage, but there's actually bedrooms in there. I plan on taking those bedrooms out and making garages out of them. So at this point, there would be 5 garages. Pardon me. And the way I was anticipating building this triplex would be to have 2 bedroom units that are over 900 square feet, and that would require 1.75 spaces for each of those. So that's 3.5. The third unit would actually be a 2-bedroom unit under 800 square feet. It's down in the full basement. I'm going to be putting a laundry facility in there, and so that would be a smaller one. And that requires 1.5 spaces, which, adding those up, comes to 5 spaces, which is exactly what the number of garage spaces that I would have, enabling people to back out onto the existing parking area, turn around, and get out into the street. So I'm not sure if I'm answering your question or not, but...
You've partially answered it. So right now there are no plans drawn up. You haven't actually physically laid out the parking and the turnarounds and...
Well, I've got it... I've gone through the numbers, and I've talked with Dwayne Ferguson, but I don't have the building permit
or layout
done yet. So I wasn't sure what I was going to be allowed to do, so I didn't want to spend a lot of time, doing multiple scenarios until I knew what I was going to be able to do, and then I would go in and everything that I'm anticipating doing is going to be, with all the proper building permits and things like that. So the parking would fit under that as well.
Okay, thank you.
Mm-hmm.
Thank you. Are there other questions of the applicant by the board? Maybe as a follow-up to Ms. Laud's comment, Mr. Burge, right now, again, staff has recommended denial of the variance, and we as a board need to discuss that. But one of the comments, one of the conditions that they've cited is that if the board were to grant this variance, that it be in compliance with the as-built survey shown by Mr. Johns. What you're saying, I believe, was you anticipate 5 garage spaces being installed with your remodel.
Right.
So
it wouldn't change the exterior of the building, just taking the bedrooms out. And actually, there were 2. If you look at that picture, I think on 22 again, just to the right of the 2-story unit, that initially was a 2-stall garage right there. And then they built bedrooms and a bathroom in there.
Sure. I need to be careful on how I ask this because I feel we as a board can do whatever we want, but I will ask it anyway. We have 2 conditions on the recommendations for approval. Would you have any opposition to us adding that 3rd condition that you've stated that you'd be installing 5 garage spaces in your
No, I don't have any problem with that at all. That's actually part of my plan. I just didn't know that would necessarily need to be a condition, for your
sure.
Approval.
Sure. Okay. Are there other comments from any of the board members? If not, does staff have any questions for Mr. Burge?
No, I do not.
If not, you probably don't even have to sit down if you don't want. I think it's going to be a pretty short public hearing. But we'll open the hearing up for public testimony. Is there anyone from the public wishing to testify? Anyone at all? Seeing and hearing no one. Public hearing is closed. Mr. Burge?
I did want to, I anticipated Mr. George being here, and I, just before I came, right after I got here, I had a letter that he had supplied. I don't know if you've had a chance to read it, but parking was one of the issues, so I had wanted to talk about that, but I do have a couple little things that may address some of the issues that he has in that letter, and I'll use that maybe as a rebuttal if that's all right. So I wanted to thank Mr. George for his perspective and appreciate his desire to make Mountain View a much nicer community. A few of the things that I wanted to address, first of all, I will be doing seeking all the current building codes and building permits for what I'm going to do. So, assuming that I'm granted this, then I will go in with the building plans and say this is what I want to do, and then and that includes parking and usable yard space as well, which I have done the math, and I don't think the usable yard space is a problem, and we discussed the parking. So far as density, that was one concern that he had, and the property is zoned multifamily, and I suppose if I wanted to, I could legally tear the building down and build a sixplex. I don't really have any desire to do that. Maybe I'm not thinking very broadly enough to, look down the future that far. But I'm not a slumlord. I'm just trying to, come up with a couple of nice properties that I can feel proud of and that can help with the community and maybe beef the community value up as well. I'm just looking to do a triplex. One thing that I think I would like to throw out there, while I would like to have both of the variances granted, if I could get the north 2.8 foot encroachment variance granted, I would be willing to tear down at my expense the east end of the building I assume it would be 10 feet. I haven't done the math on it yet, but to be able to make it compliant with the 10 foot setback requirement there, so I would not need that variance. And that space would still be available as a parking space. It just wouldn't have the building there. And I know part of his concern in his letter is that it's right up to the alleyway, which it is, and this might give a little bit of breathing room, maybe in his mind as well. And he did also say that, and he did not know any of the things that I'm, proposing to do, like the garages and things like that. So at the end of his statement, he does say that he might be persuaded if an adequate plan was in place. And I just have not ever talked with him. So, I think I could probably persuade him with what I'm looking to do. I've tried to be proactive by going through the proper channels, and I would be getting all the necessary building permits. My goal is to be a good neighbor in the community by having happy tenants that will take care of my property and the surrounding area. I have spoke with a number of the neighbors, some right next door, and as you can see from the signed letters, I have support in that immediate area for what I'm trying to do. I figured it was easiest just to state it and then see if somebody was interested in, in signing it instead of having them come up with their own letters. And two of the people that I did specifically talk with, one of them I do have the signed letter, Mr. Lincoln, is in the building just to the east, across from the alley, and the other one is Mr. Haley, who unfortunately lives in the valley and is fairly up in years and didn't feel like he could do adequate getting the letter back and forth via his computer. So he gave his a thumbs up on it, but I don't have a signature from him, and that is immediately to the north. So he is the closest person that would be potentially affected. Thank you again for the opportunity to present my case, and I respectfully ask that you approve the variance. Thank you.
Thank you, Mr. Burge. I may have one follow-up question on your rebuttal, but my first question is to Mr. McLaughlin. We have this property has, on the east side, been granted a variance for the encroachment of the 5-foot setback. Mm-hmm. What we are being, just for a clarification, what is before us this evening with respect to the east property line, is it for the entire 10 feet or for the westerly 5 feet of the easterly 10 feet of the variance? I don't know if I'm making sense or not, but is the 5 feet immediately adjacent to the alley, that has been granted already?
Correct, but not for a triplex. So if the house remains single-family or duplex, then he needs no variances. But if he converts it into a triplex, which he intends to do, then he needs to ask anew for the full 10 feet a variance.
Okay. Thank you. Thank you, Mr. Burge. Are there any follow-up questions? Mr. Vig?
Thanks, Mr. Chairman, and maybe I'll ask Mr. McLaughlin to weigh in on this one first, but the letter from Mr. George makes an assertion about that the 40% lot coverage area is exceeded, and in your determination or analysis of the case, did you find differently than that?
Through the chair, Mr. Vig, thank you. We didn't really discuss that. I didn't, in my comments, discuss the history of this property, and it's been approved for 3 variances in 1997. One of them was for lot coverage. It's around 43% lot coverage. That's the footprint of all the structure. It's a very, very large house. It's a huge house, really out of character that this big a house would be in this little neighborhood. Just a single-family house. It's really kind of stands out. So to answer your question, though, it's 3% above the maximum allowed lot coverage, and that was approved in a variance. Now, the petitioner's not proposing to change the footprint and increase the lot coverage anymore. In fact, he couldn't without requesting a variance. And in fact, he's now offered to reduce his 2 variance requests down to just 1 variance request, and make the modification to that garage so that he's not asking for 2 variances anymore. I'm sorry, I'll stop there.
Yeah, I was curious because following up on Mr. Cars's question about the change in the use extinguishes the other variance request that was approved in 97, but that isn't the case for the lot coverage variance? If I'm making myself clear, I don't know. But let me know.
Yeah. So let's just start from the ground up. So there's a fence encroachment into the primary front yard. That fence encroachment was approved for a variance. The lot coverage, there's 43% lot coverage. That variance was approved. And also the garage's encroachment into the 5-foot east side yard setback, built up to the alley, that was approved. I suspect that the reason why the lot coverage variance and the 5-foot east side yard encroachment variance were approved by the board in 97 because they were a proper building permit was applied for and approved. And then it was discovered after the fact that the building permit was in error.
Okay, thank you. And then my final point was what you what you mentioned, that the applicant has apparently offered to resolve one of Mr. George's other concerns, being the lot coverage issue.
Well, I haven't run, this is on the spot. I haven't run the math on whether or not that removal of 10 feet off the end of the building will bring it down to the 40% lot coverage. Maybe it will, but that variance stands. When he changes it into a triplex, he doesn't need to apply for the fence encroachment variance or the lot coverage variance again. Just the side yard setback encroachments, because it's this weird thing in this zoning district where when you go from being a duplex to a triplex, the yard setbacks double on you.
Okay. Thank you. That's helpful.
Thank you, Mr. Vig. Thank you, Mr. Burge.
Thank you.
With that, the matter rests with the board. Could I have a... Yes. So if I hadn't already done it, I thought I did say that the public hearing was closed, but now I've done it a second time in my mind. Public hearing is officially closed, and the rebuttal period is ended for both the staff and the petitioner, and the matter rests with the board. So if I could please have a positive motion from a board member with respect to this case. Mr. Ron.
Thank you, Mr. Chair. I'm happy to make a motion here, but I'm just not quite sure which is the best motion to make, and that's because I'm having difficulty in evaluating the standards pursuant to just a single variance request when we've heard two may be on the table, and propose, unless there's opposition by the board, that I go ahead and make a split motion, dealing with one being the north setback first, and then the east yard setback, if that's agreeable.
You have full control over the motion you make, but what you're proposing makes sense to me.
And is that perhaps an easy way to navigate through this?
I would say splitting them would be, it's definitely acceptable, and then we can address if it makes sense to pass them both, we pass both. If it makes sense to pass one and not the other, if it makes sense to deny them both. I think that keeps the options open.
Okay.
Just 1 sec. Ms. Graves, no. Do you have a question?
I just wanted for clarification, because we don't do split motions very often. In fact, I've only done them once before. Would the motion first have to be on the table in whole and then be split, Mr. Vig, or would you be able to concur as a board and then just vote on one and then the other? Usually what happens is you have a motion and then you vote to split it.
No, but my opinion is the standards are going to be different, and the discussion is going to be with respect to each of the two setbacks, on the north and then the east side. However, I'll let our parliamentarian weigh in on that.
I wish I had more experience with it myself, because it's not something that I recall either, but I agree with Mr. Carr is that they will be different. And so I think it's probably acceptable to go ahead and split it from the get-go if you care to do that.
Okay.
Thank you.
All right, in case number 2013-005, I move that we grant a variance from AMC 21.40.050G, minimum yard requirements, to allow an existing house to encroach into the north yard setback, according to department recommendations numbers 1 and 2 on page 8 of the staff packet.
Thank you, Mr. Ron. Could I have a second to that motion, please? Mr. Vague, you've indicated you'd second that motion?
That's correct.
Thank you, Mr. Vague. Mr. Ron, would you speak to the motion?
Yes, Mr. Chair, if I could gather my thoughts here, just a second. All right, regarding standard number 1, I don't agree with the staff regarding the north setback. I think there are some unique components of this lot, it being a corner lot, a single-family house on that corner lot in a multifamily residential area that is impacted by an alley and, of course, 2 street frontages as well. So I find that standard number 1 is at least partially met for the north yard setback. Standard number 2, carrying forward with my reasoning with standard number 1, zoning at the time the property was built, not addressing the difference between a single-family residence, a duplex, and a triplex, as well as the unique characteristics as a corner lot. Find that standard number 2 is at least partially met, if not met. Regarding standard number 3, for the north yard setback, I find that the hardship is not self-imposed. The petitioner has proposed something that may address some of the community concerns and issues that we'll talk about here later, but I find that standard number 3 is at least partially met. And that's all I have to say about that for now. Regarding standard number 4, I agree that the standard is at least partially met, and I think if this plays out the way that I think it may, the petitioner's agreeability to removing some garage space on the east may minimize that potential for adverse impact to neighboring properties. I agree with staff that standard number 5 is met, 6 is met, and standard number 7 may be conditional on what happens with the second variance request in that garage. So I'm open to board discussion on that standard. That's all I have. Thank you.
Thank you, Mr. Ron. Mr. Vague.
Thank you. I agree with Mr. Ron's analysis of standards 1 and 2. I don't really have a lot to add to them. I agree that they're at least partially met. It's a pretty unique physical circumstance of the property that results in the need for this variance. So it's at least partially met in my mind with standards 1 and 2. And standard number 3, again, the applicants indicated some things that they're willing to do to mitigate some other conditions on the property that I think are allow me to believe that this is substantially met in standard number 3. Standard 4, 5, and 6, I believe, are substantially met. Again, with specifically number 4, depending on how this other part of the motion plays out in a little bit, but it may actually offset some of the adverse, if there was any adverse impact to begin with. I think that it addresses the concern in my mind. And standard number 7, I think that the 2.8-foot variance request on the north is a minimum variance that will make possible a reasonable use of the land. So I believe that standard is met, and I'm planning to support the motion.
Thank you, Mr. Vig. Are there other comments by any of the board members? I will weigh in. I intend to support the motion as well, concurring with the findings of Mr. Ron and Mr. Vig. With respect to, and I tie these together, standards 2 and 3, this building has been at this location since 1965. We aren't looking to, the petitioner's not looking to change that setback, the side yard setback location, and that weighs in my decision as well, that for granting this variance. So I intend to support the motion as well. Are there any other comments? Seeing none, please vote. That motion passes by a vote of 6-0. Mr. Ron.
Mr. Chair, I'll take that as an invitation to make my second motion.
Yes. I was looking at you thinking you're just waiting.
All right. Well, let me not disappoint. In case number 2013-005, I move that we grant a variance from AMC 21.40.050G, minimum yard requirements, to allow an existing house to encroach into the east yard setback, according to Department recommendations numbers 1 and 2 on page 8 of the staff packet.
Thank you, Mr. Ron. Could I have a second? Mr. Vig, thank you. Thank you, Mr. Vig. Mr. Ron, you speak to your motion.
Thank you, Mr. Chair. Is it possible for me to incorporate by reference my support for findings 1 through 3 and 5 and 6 per the last variance? And if so, I'll let that stand for the record, and just address standards 4 and 7.
Thank you.
Regarding standard number 4, I find that with the garage fully built to the property line on the east, that this standard is not met, and that granting the variance may adversely affect the use of adjacent property. Members of the public have indicated concern about outdoor space as well as parking on the property, and think that perhaps removal of a portion of that former garage space may alleviate those issues and mitigate adverse effect on neighboring properties. Regarding standard number 7, I find that the standard is not met as well for the reasons indicated by staff pursuant to that east yard setback. The garage was an addition built according to an erroneous permit and then variance granted. So there's been a lot of jumping around to allow the garage in its current place, but with the added potential for additional residents and additional cars on the property, I think that there's necessary for change of current circumstance, and think that, again, that standard is not met if the variance were to be granted. So I do not intend to support the motion.
Thank you, Mr. Ron. Mr. Vig, would you speak to your second, please?
Thank you, Mr. Chairman. Again, I concur with Mr. Ron's analysis and find that I don't find standard number 4 to be substantially met because of potential adverse effects to adjacent properties, or standard 7, that reasonable use of the land appears possible without granting this variance, and so I don't believe that standard is met, and I don't intend to support the motion either.
Thank you, Mr. Vig. Are there any other comments by any of the board? Mr. Ron, did you?
Thank you, Mr. Chair. If we deny the variance, does that have any bearing on the previous variance that was approved by the board regarding the 5-yard setback? So if the petitioner were to maintain the property as a single-family residence or a duplex, are we reversing the prior decision by the board?
No, you're not.
Thank you.
Are there any other comments by any of the board members? I also do not intend to support the motion. I appreciate the applicant coming before us this evening, appreciate his comments and his desire to preferably keep the footprint as is. However, I had and do have heartburn with granting the variance for the east property line, as the petitioner did state. He could build this as a sixplex. You'd have to tear the whole thing down and comply with all setback requirements. I do think that this addresses concerns that were raised by some residents or a resident. So with that, I do not intend to support the motion. If there are no other comments, please vote. That motion fails by a vote of 6-0. For the record, I must read, every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That is our last case this evening, which brings us on to our items reports. I didn't have anything planned except for a report, but I believe we are down 2, possibly 3 board members. What is? Can someone speak to that?
We have 3 new members that will be confirmed on the 15th, and orientation is being scheduled for them. And I don't know the names right off the bat. I'm sorry. Do you? Okay. But we can send that to you if you'd like.
So I believe it's replacing Ms. Williams, Mr. Fink, and Ms. Denny. Is this your? Does that mean this is your last meeting? Yes. Well, at least you will be here for us to say our goodbye and thank you. I would like to say thank you for all your hard work, and you've been a very valuable part of the board and been weighing in nicely. So it's sorry to see you go.
Well, thank you. I'll miss you. I'll think about you when I'm out there falling down on my butt. The reason that I'm not renewing my membership to the board is because it's cutting into my roller derby practice.
That's an excellent reason. This may have to be off record, but are you willing to tell us your roller derby name, or is that something that we'll need to wait?
Time Bandit.
Nice. Well, I think you've got your priorities right, in my opinion. But thank you very much.
You're welcome. And you can see me at the next roller derby bout on February 2nd.
Mr. Vig?
Well, a question. Since I missed the October meeting, but did Mr. Fink indicate he was not able to serve any longer? I didn't know that he was stepping down.
I did not know that until I saw that. Was that just, is there any news on that?
I didn't request reappointment.
Okay. Boy, I thought we were a fun group to be around, too. All right. No February meeting. All right. No committee reports, I'm assuming. Do any board members have any comments? Ms. Wad? Mr. Ron? Mr. Big?
Only to second your comments, appreciation for Ms. Denny's service. Thank you.
Mr. Patrick? Ms. Denny? Again, thank you very much. With that, we are adjourned.